Welcome to the Legal Influence Podcast, a show for influencers and content creators looking to grow thriving and influential businesses legally. I'm your host, Kate Cooper. I'm a Colorado attorney, an outdoor content creator, and blogger, and I started the Legal Influence to provide accessible legal education and resources to creators. In today's episode, I'm going to debunk some common brand deal contract myths that I often see floating around online. But before I dive in, as always, I have to provide some quick disclaimers. Nothing that I share today should be considered legal advice. Everything is for informational and educational purposes only. While I am an attorney, I am not your attorney, and listening to this episode does not create an attorney-client relationship between you and I. So the first brand deal contract myth that I want to bust is the idea that you don't need an actual written contract because your emails or your DMs with a brand are going to be enough to protect you if something goes wrong. And I just want to say that is an incredibly risky and unprofessional way to do business. And I see some people giving that advice online, and it's really dangerous advice. It's possible that the emails or DMs you have with a brand could be used to establish the existence of a contract between you and that brand. But that really depends on what's actually included in them. And that correspondence is probably going to be extremely limited and isn't going to actually protect you if things go south because it's likely lacking key terms that should be in your contract. It's also going to be pretty challenging to actually prove those emails or DMs actually created a contract. That's a legal question, and you don't want to be in a situation where maybe it is, maybe it isn't. So you want to have a clearly drafted agreement that both parties have signed. And it's also worth noting that you can also have an oral contract created over the phone or during a conversation. But again, that's going to be very problematic because it's going to be extremely difficult to prove what someone else said. So if you have a call with a brand where you discuss the terms or details of a partnership and you come to an agreement on certain terms, make sure that you are putting all of those terms into a formal written contract. And in general, all business transactions should have a written contract involved. And brands typically expect to use a contract. They're probably going to be the party to actually provide the contract. So getting one shouldn't be an issue in most cases. And if it is an issue for some reason and the brand is refusing to sign one, that's a pretty big red flag that the partnership either might not be legit or the brand is acting in bad faith. So it's really important to get all of your brand deals in writing and signed by both parties so you have that contract readily available in case there's a dispute and you need to potentially enforce it. So the next myth that I want to bust is the idea that the contract you get from a brand is going to be fair and adequately protect your interests. Now, in a perfect world, that would be the case. And every now and then you may come across a contract from a brand with fair terms. I know I've seen a handful that have really fair terms, but there is a very good chance that the contract you get has been drafted to be one-sided and favor the brand. That is the overwhelming majority of the brand deal contracts that I see. And especially if you're working with a really large company and you're dealing with a lengthy contract that's filled with lots of legal jargon, chances are it's the brand's stock contract template drafted by their corporate counsel that they use for all of their creators. And it makes sense that that type of contract is going to be drafted in a way that really protects the brand's interests as much as possible. So when you go in to review a contract from a brand, it's just safe to assume that it has been drafted to protect the brand, and you'll probably have to advocate for yourself and negotiate new terms. And if you want to know what to look out for and how to communicate changes to brands, I want to let you know that the doors to the Brand Deal Contract Academy are now open. This is my new self-paced course that is specifically designed for influencers and content creators who work with brands. You can find more information about the course and how to enroll in the show notes. I'll also be talking more about the course later in the episode, but I wanted to bring it up now so you know that there's a resource available to assist you if you need it. So the last myth that I want to bust is the idea that the contract you get from a brand is non-negotiable. It's take it or leave it. So it's not even worth trying to make revisions to it. You should just sign it and go. And I want to let you know that it is completely normal to negotiate the terms of a contract. Again, especially in a situation where the brand knows the contract that they sent over is one-sided or unfair, as we just discussed. During any sort of business negotiation, you're probably going back and forth on the terms a few times. And if you're making reasonable requests for changes, then chances are the brand is going to agree to them. In my experience, brands are typically pretty reasonable, especially during partnerships where it's clear they want to work with you specifically, and they've already invested a lot of time and energy into negotiating with you to come to an agreement in the first place. So most brands are going to be willing to work with you and revise the terms of the contract to make sure that you feel comfortable about signing it. And if a brand isn't willing to work with you and revise terms that in your opinion are reasonable, then the ball is in your court to decide whether or not you want to agree to the terms as is. But remember, it's a brand partnership. It needs to be mutually beneficial, which means making sure that the contract adequately protects both parties. So I don't want you to be afraid to ask for changes to your brand deal contracts. As I mentioned earlier, the doors to the Brand Deal Contract Academy are now open, which means you can officially enroll in the first cohort. This is a brand new program that I'm launching that is designed for influencers and creators who work with brands. A really common question that I get often is, I don't know what to look for when reviewing a contract. You may know that you need to look out for things like surprise usage terms or exclusivity terms, but you don't know how to spot risks and potential red flags, or you don't know what certain legal terms really mean. And that's what the Brand Deal Contract Academy is there to help you with. I always say you don't know what you don't know. And so I really wanted to create a comprehensive resource for creators so that you do know what to look out for and you feel confident throughout the entire process. So I want to talk to you a bit about what's inside the Brand Deal Contract Academy in case you're interested. So this is a self-paced course, which means once you enroll, you'll get access to all 5 video lessons in the course. And those lessons cover how to review a brand deal contract, a deep dive into different contract provisions, including what they mean with examples from actual brand deal contracts. We go over how to review and redline your brand deal contracts, and then I cover how to finalize your contract and have a successful brand deal. In addition to the video lessons, the Brand Deal Contract Academy also comes with some bonuses. So you'll get a copy of the Content Creator Contract Glossary that defines over 30 common contract terms. You'll get some custom templates, including a revision provision template and email templates to help communicate contract revisions and changes to the brands. And you will also have the opportunity to join me in an office hour session to ask questions about the course or brand deal contracts in general. And the exact date and time is going to be based on everyone's availability. So that's still TBD, but it's probably going to be sometime during the first week of June. So that gives you enough time to get through the course without too much time passing, so it's still fresh in your memory. So since this is the first time that I'm launching the Brand Deal Contract Academy, I'm offering it at an introductory price of $167. And you also have the option to add on my influencer agreement template if you want to have your own contract template available and ready to go. You don't need your own template to go through the course, but I always recommend having one so you can easily pull language to make revisions to the contracts that brands send over. And I usually sell the influencer agreement template for $147, but you can snag it for $80 when you enroll in the Brand Deal Contract Academy. So again, if you enroll, you get access to all the video lessons, the contract glossary, the custom templates, and an office hour session with me. I've been working so hard to perfect this course and make it as educational and actionable as possible. So I'm really excited to finally get it out into the world. I really hope to see you inside. The doors are now open and they will be closing on May 20th. So make sure you enroll and I hope to see you there. Thanks so much for listening to the Legal Influence podcast. If you enjoyed today's episode, I'd love for you to do me a favor, screenshot this episode, share it to your Instagram story, and tag the Legal Influence. Also, be sure to leave a rating and review. That really helps me to grow the show. And if you know any influencers or content creators who would benefit from this episode, please send it on to them. Talk to you soon.